A non-compete agreement is enforceable if it's reasonable. Now, what a non-compete agreement is when you first get hired, a company may ask you to sign one. And in that agreement, it says that if you stop working there, you will not set up your own business that competes, or you will not go to work for a competitor in that business. States don't really like non-compete agreements that much because it restricts a person's ability to earn a living. However, if the non-compete is protecting certain types of secret information, and if it's for a reasonable length of time, which can vary depending on many factors, or if it's for a regional geographic scope, then it often will be enforced. A non-compete which said, you can't form a competing business or go to work for a competitor within 1,000 miles of here is not one that would be reasonable. However, if it's one that's maybe the county you live in or a certain number of miles, 25 miles from the business, then that's something that would be reasonable. The same issue would be at stake too as far as the length of time. If they say a very long length of time, it will not probably be considered reasonable by the courts. However, if it says a year or two, that probably would be considered reasonable. Before you sign a non-compete agreement, you should try to figure out what it is that's being restricted, and you may want to speak to an attorney prior to signing to be sure that it's not a non-compete that will come back to bite you at the end of your employment.